So, good afternoon, all the participants. So, we are back with session 2 for uh, 2 days online workshop on intellectual property rights for computer related inventions. So, today for session 2, in session 2, we will be focusing on IPR for artificial intelligence, machine learning, and IoT related inventions. A very interesting topic for the participants from computing background. And for this session today, we have Mr. VIJAY KUMAR MAKYAM. Sir is a postgraduate in law with specialization in intellectual property rights and Master of Science in Information Technology, and had practiced intellectual property laws for 15 years. He had initially enrolled with the Karnataka Bar in the year 2005 and got transferred to Telangana Bar. He had been counsel on record in various IPR cases before different high courts in the country. He had been a guest faculty or resource person at various well-known universities like National Institute of Micro, Small and Medium Enterprises, Hyderabad, National Institute of Pharmaceutical Education and Research, Hyderabad, University College of Law, Osmania University, JNTU Hyderabad, JNTU Kakinada, Ministry of HRD, Ministry of MSME, and various other universities for promotion of IPRs. He had attended JPO training course for practitioner specialization in patent from 22nd August to 7th September 2017. He is a registered patent and trademark agent for Indian Patent and Trademark Office and has filed and prosecuted patent and trademark applications and oppositions before the Controller of Patents and Trademark Registrar in India. He has also coordinated filing of patent and trademark applications in some other countries like USA, Europe, Australia, Malaysia, Singapore, Sri Lanka, South Korea, South Africa, UAE, and Japan. He has published an article titled Unintentional Abandonment of Patent Applications Law in India in Anishi number 19 during August 2018. He is instrumental in organizations like organizing various seminars, training sessions, and moot court competitions. So we are glad to have you, sir, and I heartily welcome once again. And also, we are thankful to you for providing your valuable time for this workshop. Thank you very much, sir. Hello, Vijay sir. Participant, just be online. I think we are facing some technical aspect. Yes, Vijay sir, are you able to hear my voice?
Yeah, I'm back. I'm sorry. There is
Sure.
some internet
Yeah.
problem.
No issue, sir. So, sir, we heartily welcome you and thank you very much for sparing your valuable time.
Thank you. Should I proceed ahead with my
Yes,
presentation?
sir. Yes, sir. Your slide is visible and you can start this session.
Great. Very good afternoon to you all. Thank you for inviting me for this seminar, 2 days national workshop. Before I begin anything, I would like to give a formal disclaimer that this is only academic purpose. It is not a professional advice or something like that, or nor these presentations bind on my organization or myself for professional activity. In case you have every case is fact specific, and we need to relate the subject to the fact. So in case you have any if you require any professional help, you may contact me separately. I think yesterday someone has actually given a lecture on various types of IPs and what they are and all. So, in a nutshell, what is a legal right, for what it is given, and how it is accorded, have given along with a pictorial representation in this slide. So, patents are given for new inventions on application and examination. It is not automatic. You need to make an application, and that will be examined by the government, and then a patent will be granted. Something like a machine or something like that will be given patents. Copyrights will be given for original, creative, or artistic form of expressions which you make. It is automatically exists. You don't require to file any application. You just write on a piece of paper, it automatically exists for you. Only the thing is, you need to prove that you are the first person who have written it. So that is copyright. And then trademark, it is for a distinctive identification of product and services of your company or your services. That is it is based on use as well as based on application and registration. So you may without registering also use a trademark. When you continuously use a trademark, it will be recognized as your trademark. If somebody copies, that will be protected to you because you are the prior user. Or you can also register the mark and get a statutory protection. Something like Google is a mark that has been registered to Google Incorporation. Then registered designs. Here I'm saying registered designs. It is only on registration. The designs, if you make a design, it may initially you get a copyright, but the moment you make 50 products of that design, copyright expires. And if you don't make an industrial design registration application, that will not be registered to you. What will be protected to by registered designs? It is external appearance of a product. Then there are what are called trade secrets. In India, we don't have a separate law, but trade secrets are protected under Indian Penal Code, Indian Contracts Act, and law of torts. All this protects you trade secrets. Any valuable information which is not known to public and which is important to your business can be protected as trade secrets, and you need to keep reasonable efforts to keep it secret. So this is in nutshell various types of IPRs. Now, one single product will have multiple types of intellectual property. So I said there are various types of intellectual property. In a single product, all these types of intellectual property can be seen. For example, in this Coca-Cola tin can, Coca-Cola as a name, brand name, a trademark can be registered and protected. And then a patent for technology of ring pull can. And the drink formula, the drink itself, the recipe or the formula of the drink itself is a trade secret. And the logo, design, everything, the image content can be a copyright. And the shape of the can itself can be a design. So all the 5 IPs, one single product can have all the 5 types of intellectual property rights. Now check what type of intellectual property is been applied to this guy. There is this person called Likith. He's a software developer in a company called Promax AI Services. Developed a product called GymFix that customizes a gym equipment. You all see the gym equipment, right? This gym equipment will be customized based on the user's body vitals. If a thin guy is there, he can't lift the weights. So according to his body vitals, the computer adjusts the gym equipment. So that is what he has invented, and he would like to publish his invention in a book form and wants to, before he goes ahead in publishing and all, Promax AI Services wishes to protect his intellectual property before publishing the book. Identify different types of IP that can be protected by the company. Can you just let me know what are the different types of intellectual property? Is it the technology itself can be patented? The book he is writing can be copyrighted. The word GymFix is a trademark that can be protected as a trademark. So likewise, there are several types of intellectual property available in one single invention or one single product. Now, what is patent? Patent is a legal title granting its holder the right to prevent third parties from commercially using an invention without the authorization. So without my authorization, nobody can use the invention what I have made. That is what is a patent. Why this patent is granted? In return of this protection, the holder has to disclose the invention to the public. Only when you disclose the information about your invention to public, then patent will be granted to you. It is give and take policy, quid pro quo. We call it quid pro quo, Latin terminology. I am giving my invention details to public. Public, represented by central government, is giving monopoly rights to that invention to me for a limited period of time. The limited period of time is generally it is 20 years all over the world after TRIPS agreement, trade related aspects of intellectual property rights. That agreement has been signed. It is WTO agreement, which is signed on 1st January 1995. After signing that agreement, the law around the world has been harmonized. Earlier, the period of protection is different in each country. US had 20 years, India had 14 years, some other countries have 7 years, some other countries has 5 years, 6 years. So there were differences in granting term patent grants. However, after signing TRIPS agreement, everyone made it 20 years, unique throughout the world, harmonized throughout the world. Then patent is geo-specific. It is not for the entire world. Once you invent, your invention will not be protected throughout world automatically, unlike copyrights. Copyrights is like that. Once you write a book, once you publish it or register in one country, automatically all 164 countries of Bern membership is automatically protected. You don't really require to get it registered in the country where you have living or where you want protection. It is automatically protected under copyright law. However, patent law is not like that. Patent law, you need to file applications in each and every country separately. If you want protection in India, you need to file application in India, get it protected. And if you want in USA, you need to file application in USA to get it protected. If you have not filed an application in a particular country, that country people are free to copy the technologies what you have disclosed. So disclosure is global, protection is geographic specific. That means once you file a patent application in India, protection will be granted only in India, but you are disclosing this idea throughout the world, in USA, Africa, Arab countries, or Australia. Anybody can see what you have filed, but protection you get only in India. If you want protection in other countries, there are international conventions and international agreements like Paris Convention is one old 1883 based agreement which provides 12 months time frame for you to file in across the globe where you have market to this invention. You can file application after filing in India. Within 12 months, you can file in other countries and get it protected. There is another international treaty called Patent Cooperation Treaty, which within 12 months, if you file PCT international application, it provides 31 months time for you to file in across the world and get it protected. If you don't file applications in other country, you won't get protection in those countries. Likewise, if a US company or US citizen makes an invention and files application in USA, if US Patent Office grants a patent, that doesn't bind on India. Indian people are free to copy the technology. So if US company or US citizen comes to India and files an application in India, then only it will be protected in India. Otherwise, we are free to copy that. So this is a very simple aspect that you need to understand, that patents are only territorial, geographical specific. It is not worldwide. If somebody has US patent, he has only protection in US, not in India. So you don't require to pay any royalty to him. Now, what is a patent in a legal terminology? Patent is a right to monopolize an invention. An inventor specifies the scope of activities from which he wants to exclude others, so that he calls it as claims. I claim to be inventing XYZ machine, and I am claiming that XYZ machine as claims and submit it to the patent office. Patent office evaluates whether these claims depict an invention within the sense of patent law, within the meaning of the patent law, whether this invention, what you are claiming, is really an invention or not. They'll check it. That is called formal examination. And some patent office examine whether the invention is new and non-obvious, whether it is really new, really has inventive step. That is called substantive examination. So if these two examinations, formal examination and substantive examination hurdles have been crossed by your invention, then the patent office will grant a patent exclusive right to produce and market the invention for a period of 20 years. It is a negative right. Why it is negative right is we will prevent third parties from using from commercially using it. It is not allowing you to manufacture or distribute it. What right you get is you you can prevent third parties from manufacturing and distributing without your permission. So it is in a way negative right, a right given to you to stop all others. That is the way it has been given. So it's called negative right. Now, what not to do when you are considering to file a patent application? Most often, especially in academic institutions, people go for publications. So there is why publications is there is the AICTE requirement or UGC requirement to get promotions and all for professors, and for students to get admissions in reputed institutions. There should be publications. So that's the reason people in hurry to publish their research work and all, and they go and file publication. After publication, people suggest them for filing patents and all. When they come back to file patent application, their own disclosure in the market in the as in form of publication will hamper their getting a patent grant. That's the reason no publication before filing patent application. You need to first file patent application, then publish it. You should not write any article. You should not press release. These days, social media apps, Twitter, Facebook, and Instagram and all are catching up. So the moment you get an idea, you post it on Twitter, you post it on Facebook, you post it on Instagram. So all this will be hurdles to get your patent. So you should not do that. And most often my clients come to me and say that, sir, I am selling this product. This is a great product, sir. It is moving in the market like anything. I want this product to be protected in the patents. You already on the sale. Already everybody knows what the product is. You can't sell it. More importantly, for software invention, software type of invention, they say that, sir, the front-end software is already everybody using it, but back-end code, what happened, nobody knows, sir. So I want to file patent application for that. Still, once the product is out, once the product is on sale, incorporating the invention, you can't file patent. Even if you file, that will be refused based on your sale of this product. Then you should not give any lecture or presentation about your filing, about your invention before filing. Sometimes it is if it is not possible for you to construct a machine or product without disclosing the idea. Sometimes what happens is you are under obligation to disclose for testing purposes or for fabricating your product or for various other purposes, getting finance or whatever it might be. At that point of time, you need to disclose, but under NDA, non-disclosure agreement. You need to make an agreement with the person whom you are disclosing, for what purpose you are disclosing, what he need to do with the disclosure, and how he need to come back to how he need to deal with that information what you have shared with him. So that agreement you need to make before disclosing. Then seek professional advice. File application before others do. It is first come first serve basis. Unlike earlier in US, it is first to invent system. First to invent system in sense, whoever first invents, he'll get the patent, not the person who first files in the patent office. So they used to maintain lab notebooks and all, and then they used to provide evidence of lab notebooks to say that he has invented first and all, and then he used to get. But that is too many litigations happening, and US has done away with that. And even in India and other countries, most of the countries, it is first to file. Who files first application, who invents first is immaterial. Whoever runs to the patent office and files the first patent application, he'll get. Even fraction of 5 minutes, 10 minutes will be making a big difference in getting a patent grant to you. If you file 5 minutes before, after 5 minutes, your other friend files, you will get a patent, the other friend will not get a patent. So what are the requirements for grant of a patent? There are essentially three primary requirements, that is novelty, utility, non-obviousness. But however, I have added two more requirements, that is patentable subject matter and specification. Unless these five requirements are like filters. If you pour inventions from the top, if it crosses one filter after the other filter, finally once it crosses all the filters, you get a patent grant. So unless it is patentable subject matter, unless it has novelty, unless it has utility, unless it has non-obviousness requirement, or unless it is not properly disclosed, it will not be granted patent. So these 5 requirements are quite essential for getting a patent grant. Now let us look at each of these requirements. Patentable subject matter, this requirement lays down the list of eligible subjects to get a patent and subjects that those are not eligible as non-patentable inventions. For example, in section 2J of Indian Patent Act, it says what is an invention. Invention means any new product or process have involving inventive step and capable of industrial application is invention. That is what has been defined as a eligible subject. Any new product or process, no technological barriers, only only pharmaceuticals, only automobiles, only. It is not defined like that. Any product or process, any technology is what definition of section 2J. What is an invention? And then what are not inventions has been defined under chapter 2 of the Patent Act, which is from section 3 to section 5. Section 5 anyways has been deleted in 2005. That is only process patents for pharma and food products earlier, but now for drugs and food also been getting product patents. Earlier it was not there. 2005 it has been removed. Now there are only 2 sections in chapter 2 of Indian Patent Act, that is section 3 and section 4. Section 3A to section 3P, there is a long list of subjects which are not eligible to patenting, including computer programming, business methods, mathematical operation. All those things are not patentable. Traditional knowledge, frivolous inventions, synergetic combination, all these are not subjects that can be patented, is what section 3 lays down. And section 4 says about atomic energy related patents are not patentable. So these 2 sections are relevant for the purpose of understanding what is not patentable. In order to comply with the subject matter requirements, the invention should fall under eligible subjects. It should be any new product or process, and outside section 3 and 4, non-patentable inventions. So that is what the patentable subject matter requirement is. Novelty, it should be new in light of prior art. We call all technological arts, automobile arts, information technology arts. So we call it as an art, technological arts. So anything that is existing as on today is called prior art. Whatever is existing today is called prior art. So your invention, whatever you have invented today, it should not exist in the prior art. If it is already existing in prior art or in public knowledge, or it can be easily anticipated, those things are not considered as novel. That's the reason I said in the previous slides, it should not be on sale, or it should not be disclosed in any publication and all. So if it is in public domain, public knows about this, that can't be patented because it lacks the requirement of novelty. Even a PhD thesis, you have written a PhD, your own PhD thesis, you have given it to the college, and college kept it in the library, college library. College library is a public place, and today you have kept it, tomorrow you have filed a patent application. Still, because the thesis is available in library, which is a public place, which is available to everybody yesterday itself, and today you are filing, which is already existing in the prior art, will not be patented to you. It is not meeting the requirement of novelty. Then non-obviousness. Non-obviousness is the invention should be it should have some kind of inventive step. It should not look obvious to technical person skilled in the art. Ordinary person skilled in the art, not a PhD guy, ordinary technical person skilled in the art, that guy should see that there is some inventive step involved in your invention. Suppose, for example, you made a chair. There is a chair existing with 4 legs already in the market. You removed 1 leg and made with 3 legs a chair. So is there any inventive step involved in that? You have just cut down, though it has economic significance. There is no technological advancement, but there is an economic significance. Economic significance is without having 4th leg, you have balanced the chair on the 3 legs. So the cost is cutting. So if it is cost cutting, then it is considered to be non-obvious and patent will be granted. If there is no technological advancement, no economic significance, or if it has both technological advancement and economic significance, then it is considered to be non-obvious, and patent will be granted. Otherwise, it should be considered as obvious, and the patent will be denied. Then it should be useful in industry. Even if it is used for one single individual, the requirement is met. Like bone marrow patient is there, you have found out a molecule or a drug for him, that can be patentable. However, industrial application has a wide definition, which is it need to be repeatedly by your specification what you have submitted to the patent office. By reading that, I should be able to manufacture that product and repeatedly manufacture that product in the industry. If there is no raw material, I can't able to manufacture it, then there is no industrial application. Or if you don't know, suppose you have made a machine, but how do you made, you forgot about it. You made the machine is working perfectly fine, but you can't make a second machine. So in such situation, there is no industrial application, and patent will not be granted to such inventions. And then finally, you require to draft a complete specification. You need to, it is not the prototype that you are going to take to the patent office. It is the specification what you write, that you will submit to the patent office, and patent office evaluates that specification, reads that specification, understands the specification, and grants a patent to that specification. So you need to very clearly write what is the invention about, how it is constructed, how many parts are there, how those parts are connected, how the overall machine performing, everything you need to write. If there are several ways of manufacturing it, what are the different modes of manufacturing, what is the best according to you, all that you need to written very well. And you also require to give the boundaries of invention. So what is that you are claiming, what is that other people need to stop using, is what you need to write in the specification to create the boundaries of invention. You may take the help of drawings. You need to specifically write claims. If there is no claim, patent application will not be processed, patent application will be rejected, saying that there is no claim. So you need to write the specification and write what is your claim. You may write 100 things, but what is that you have contributed should be going in the claims. So that claims are quite important. The claims should be supported by the description, whatever 100 things you have written, that in that what is that you are claiming should be there. So that claims should be supported by the description. Let's see this video. Hope everybody is able to hear the audio.
Let's do something a little more fun. How about combat training?
So this is a movie clip from a movie called Matrix. Here what's happening is there is a floppy disk which has kung fu art, is copying and pasting in the brain.
Oh shit. Mikey, I think he likes it. How about some more? Oh yes.
So there is a wire, the person sat on a chair, there is a wire, the floppy disk has kung fu art fighting, and that has been transferred to this person. Will this be patentable? Is this invention qualifying all 5 requirements? That is patentable subject. Is it a patentable subject matter? Is it new product or a process? Yes, it is a kind of a product, and a process is also involved, transferring of data into human brain. Then the second question is whether it is novel or not. When is this movie released? Matrix released quite long back, right? So exhibition of this kind of a movie, is it hampering the novelty? No, this is a fictional thing. If it is a documentary kind of a thing, a really happened thing, then it would have acted as a prior art. But this, since it is a fictional thing, it is not. So novelty also it is qualifying. It is patentable subject matter, it has novelty. Then comes non-obviousness requirement. Is it obvious? Is it very simple thing? It is not. So it is qualifying obviousness also. Then whether it has any industrial application. Today we don't require this kind of seminars or training programs and all that what we require is floppy disk of a subject. That disk can be kept in the computer, and knowledge is transferred to the brain. So that is the scope of the invention. That it is definitely useful invention, and it can be repeatedly made. And finally, whether a specification can be written. Yes, a specification can be written and patent can be granted to it. So these are the 5 requirements you need to check like this. Any product you have made, these 5 requirements you need to check. So here, particularly this invention might fall under section 3, non-patentable subject matter, because the end product is human being involved in it. If there is no human brain involved in it, the product would have been patented. But since a human being involved in it, that might be a question mark, because plants, animals, and parts thereof are not patentable under section 3. Let's see another video. Sorry. This video I have taken from one of the Bond movies.
Security announcement. Passengers are asked not to leave their baggage unattended.
Guten Tag, kann ich Ihnen helfen?
Ja, mein Büro hat ein Auto reserviert.
Einen Moment bitte.
Danke.
So there's James Bond
If you just sign here, Mr. Bond.
who got a new car. He's asking him to sign
It's the insurance damage
Insurance.
waiver for your beautiful new car. Will you need collision coverage?
Yes,
Fire?
probably.
Property destruction?
Definitely.
Personal injury?
I hope not, but accidents do happen.
They frequently do with you.
Well, that takes care of the normal wear and tear. Do I need any other protection?
Only from B007, unless you bring that car back in pristine order. Shall we?
Shall we?
So he's now going to show the car.
Your new BMW 750. All the usual refinements. Machine guns, rockets, the GPS tracking system.
Welcome. Please fasten seatbelt and obey all instructions for a safe trip.
Thought you'd pay more attention to a female voice.
I think we've met.
I am not interested in your sordid escapades. Let's get on with it, shall we? Your new telephone. Talk here, listen here.
So that's what I've been doing wrong all these years.
Look, it also includes a fingerprint scanner and a 20,000 volt security system, and this I'm particularly proud of. The remote control for your car. Tap twice. 1, 2. Now, draw your
So it is an invention which starts the car by tapping on the phone. And you can also drive the car using
It's surprisingly
the
difficult to drive, but with practice.
Well, let's see how she responds to my touch, AQ.
so the Bond drives it through his mobile remotely. So all these inventions, the software has been used to work all this. Definitely it is an automobile invention, but then there are a lot of software coding went into this to get this invention done. Is software patentable? Is this all technologies, maybe a GPS, a biosensor, or GPS tracking system, or a female voice coming in the car, or the driving system itself? Are all this patentable? Again, the same requirements: subject matter, novelty, utility, non-obviousness, and specification. If these 5 requirements are met, all of these are patentable. Now let us briefly overview what's the patent system in India. The moment you have an idea conceived, you file a provisional application, If you have complete data, you can as well file complete specification directly. In case you file provisional application, you will be given 12 months time to file a complete specification. You may, in case you don't have complete experimentations done, you may post-date your provisional applications to maximum of 6 months, and then your due date for filing complete specification also moves. So according to, if you file a provisional application, you have maximum of 18 months time. However, if you cross 12 months, your date of filing provisional application will also move on. Then after 18 months of your filing application, your application will be published. You can as well make a request for early publication. Once the application is published, it is open for pre-grant oppositions. 6 months is a mandatory period where controller will wait for pre-grant oppositions. If there is no opposition, or if the patent, if the invention has no objections, like it is meeting patentable subject matter, novelty, utility, non-obviousness, and specification requirements, then he'll straight away grant the patent. Otherwise, he'll issue a FER. However, for issuing FER, the applicant required to make a request for examination. This request for examination application has to be filed within 48 months from the date of application. Only when you make a request for examination, then your application will be queued for examination. Otherwise, your application will automatically abandon. Once FER is issued, once objections have been issued, objections will be, it is not patentable subject matter, it is not new, it is already, there is some technology existing, some D1 document is existing, similar technology, why should we grant a patent and all. Once FER is issued, you are expected to reply, file a response within 6 months. I'm sorry, the slide shows 12 months, but it is 6 months. Earlier to May 2016, it was 12 months, but after May 2016, the patent law has been amended, and the time frame for replying FER is made 6 months. If the reply response is satisfactory, they grant. If it is not satisfactory, they call for a personal hearing. After hearing you, they refuse the patent. Once the patent is granted, it is open for post-grant opposition for 1 year time frame. Anybody interested can file a post-grant opposition for grant of the patent, claiming that it is not meeting requirements of grant of a patent, that is not patentable subject matter, not novel, not having non-obviousness inventive step, or it is not having, it is lack of industrial application and all. Then once it is granted, first 2 years are exempted for filing renewals. After that, it need to be renewed every year. Then you also require to file a statement called working of patents every academic year. After academic year, after 31st March, from 31st March till 31st September, within 6 months, you need to file working of patents. If you don't manufacture the product, don't file the working of patent, it is subject to compulsory license. Anybody and everybody can manufacture since you are not manufacturing. And it is also subject to revocation proceedings. This is the entire overview of Indian patent system. Now, coming to the point, artificial intelligence and software. Technology is backbone for any digital economy, and much of its value lies in software. Indeed, all economic sectors are becoming reliant on software to leverage growth. This has important implications on intellectual property. Until late 20th century, the functionality of most innovative products, particularly those relying on semiconductors, was primarily embedded in hardware. There was no doubt about their patentability. Hardware are definitely patentable. But today, increasingly sophisticated semiconductor technology and design tools means that physical objects are no longer the sole basis of innovation. In other words, technical functionality in progressively migrating from hardware to software. And yet, in many jurisdictions, software-related inventions either do not qualify for patent protection or have a very limited scope of protection. This need to be harmonized throughout the world. That's the reason TRIPS agreement came in. TRIPS agreement article 27.1 says patents shall be available for any invention, whether product or process, in all fields of technology, provided that they are new, involve inventive step, and capable of industrial application. That was article 27.1. However, article 27.2 and 27.3, they have given some flexibilities to member countries. Members may exclude certain subject matters like plants and animals, computer programs, and business methods are not expressly excluded, are businesses are not expressly excluded from patentability, but members can exclude them. In Article 27.1, they say that it should not discriminate anything. And Article 27.2 and 27.3, they have given some flexibilities. And Article 29.2, the applicant shall disclose the invention in a manner sufficiently and clearly clear and complete for the invention to be carried out by a person skilled in the art. So the person skilled in the art need to able to, once they read the specification, they should be able to construct that machine, that product altogether. That is how you need to disclose. However, the terms invention and technology has not been defined under TRIPS agreement. Members may define the term inventions in their national law, and there is no requirement to submit source code or object code. Now, why we in a computer to bring about a certain result, a set of in logical human readable instruction code into computer language. Then object code is result of the compilation of source code into machine readable instructions. So why protection is needed? Modern society relies more on software. Everything today you take is built on software, and it is easy to copy, easy to reverse engineer. And if protection would not be provided, the software would become very costly affair. And which category of IPR you need to protect? It is copyrights, patents, and trade secrets. Copyrights, for sure, it will be protected. Patents, yes, if it is, there are certain criteria which we'll see in the coming slides in which areas of the software can be protected. And if you don't disclose it, it becomes a trade secret. So we have algorithms, source code, object code, the executable code, the GUIs, look and feel, all this can be protected. Copyright for software, source code can be protected as a letter. Like you write a poem, you are writing a source code, so source code can be protected. Screenshot with description of each screens as a user manual or a booklet can be protected as a literary work. Executable code as a computer program, and computer generated graphics as artistic works. So the difference between copyright and patent is copyright protects the expression of idea. The idea per se is not protected. Expression of idea. If I make a accounting software, debit, credit, and all, in some language, maybe I'll make in C language. Somebody can take the same idea, make it in some Oracle and all. He can make a similar software, Visual Basic or Oracle, whatever it might be. So the expression of idea is protected, not the idea per se. So idea is open for other people to copy it. Whereas in patents, the idea manipulating that technology itself is protected. Nobody can manufacture that software without the permission of the patentee. It is only symbolic features of the product will be protected. Whereas here under patents, it is functional aspects, what the software does, that will be protected. Literal elements in copyright, non-literal elements in patents. Copyright protects the expression of ideas and not idea itself, whereas software can be easily reverse engineered. Only screenshots and look and feel can be protected. Protection occurred only for the reproduction of software. So thus, patent protection is required. Patent protects idea manifested in the form of product or process. That's the reason it is essential for software to be protected under patents. There is other form of protection which is called trade secret protection. The requirements are, it can be any information, it can be program, process, design, architecture, document, compilation pattern, which has independent economic value and not generally known to public or readily ascertainable, and you have taken reasonable efforts to protect it. Those kinds of things are protected under trade secrets. So you can protect the trade secret by putting reasonable efforts of employing a security guard, expressing duty of non-disclosure, sometimes restricted access, escrows and passwords, and marking it as confidential, and having a security system and policy that will protect the software under trade secrets. Misappropriation is a conduct which is result in obtaining the trade secret by improper means constitute misappropriation. It can be criminal conduct by theft or trespassing and all. It is breach of contract, you being an employee of a company in confidence that has been given to you and you have breached that confidence. Or it is a tortious liability, master servant relationship or husband wife relationship, tortious act. So those are all improper means that can be bring action on misappropriation. So these are the requirements of patentability: patentable subject matter, utility, novelty, non-obviousness, and specification. Only when these requirements are met, patent will be granted. It is the same in US. In US, there is what is called Title 35, which is US patent legislation, and then Federal Circuit Court decisions, and then Manual of Patent Examiners Practice is what guides to determine whether a particular subject is patentable or not. Now, Title 35, Section 101 says, whoever invents or discovers any new and useful process, machine, manufacture, or composition matter, or any new and useful improvement thereof may obtain a patent therefore, subject to the fulfillment of the conditions of Title 35. So that is what is the definition of subject matter. It can be any new and useful process. It can be a process, it can be machine, it can be manufacture, it can be composition of matter. It is anything and everything on the world is what is been granted protection. And there is one case law, very important case law, happened in US in 1980, that is Diamond versus Chakravati, which said anything under the sun that is made by man, anything under the sun which is not naturally existing, not automatically existing, but involves human hand to make it, that can be protected, is what US Supreme Court said. That opened the gates for software patents as well. So categories as under Section 101 of US Patent Act, that is Title 35, is process, machine, manufacture, composition of matter, or improvements. Then there are some judicially exclusions. The courts have excluded certain subjects are not patentable. Something like abstract ideas, making a time machine is an abstract idea, physical phenomenon or laws of nature, mathematical algorithm. So in this video, I think last time we have seen that the essential thing is software, whether software is patentable. Programming similar to writing symphonies. When a programmer writes software, he weaves together thousands of ideas, algorithms, or calculation rules into a copyrighted work. Usually, some of the ideas in the programmer's work will be new and non-obvious according to the standards of patent system. When many such ideas are patented, becomes impossible to write software without infringing on patents. Software authors are in effect deprived of their copyright assets, and they live under permanent threat of being blackmailed by holders of large patent portfolio. As a result, less software is written and fewer new ideas will appear. So this is what people fear of if software gets patented. Now the question is it really software patentable? Why we are discussing whether software patentable or not is software is nothing but mental processes, ideas, and mathematical formulas, and not technological things. Writing program code is a mental process and mathematical procedure. It is not a technical factor. Only the use of program has some technical effect, not the program by itself is technological. The use of that program into some product is technical. The computer remains the same. The laptop or desktop what you are using remains the same. Therefore, it is not considered new. So all this is their essential aspect is that the core of the software technology is the execution of complex logic. So logical things, anybody has to say logical things the same, right? So why should protection be granted? The execution of complex logic is for the most of the skill exclusive to human being. In the patent world, this kind of technology is called mental steps, and for a long period of time, this mental steps was not considered patentable. Now in US, from 1960s to 1970s, no protection if invention used a calculation made by a computer has been the situation. From 1980s, after Diamond versus Chakravati case, some computerized inventions are patentable. And in 1990s, almost all software are patentable. But in 2000 onwards, codes start pulling back. Only software tied to particular machine or apparatus, or software transforms a particular article into a different state or thing. Those softwares can be patentable, is what the USPTO said. The first guidelines USPTO issued is 1968. These guidelines stated that computer program, whether claimed as an apparatus or a process, was unpatentable. Under these guidelines, an invention relating to programmed computer could be patentable only if computer were combined with other non-obvious elements to produce a physical result. So only embedded software which claims rejected by the patent office. The same thing has been sustained by Court of Appeals. Then it went to the Supreme Court. Supreme Court reversed the decision and said that the court felt that the patent of this concept would preempt the entire mathematical algorithm. Since mathematics could be considered an abstract idea and abstract ideas are not patentable, the Supreme Court held that the algorithm in question is not patentable, which does not have substantial practical application. If it had substantial practical application, patent could be granted, but because it does not have any substantial practical applications, patent should not be granted, is what court has reasoned. Then Parker versus Fluke is 1978 case, in which an invention involving a method of updating alarm limits, patent office rejected. Court of Customs and Patent Appeals rejected the patent examination, held the invention patentable subject matter. Supreme Court reversed the decision and said that it is non-statutory subject matter under 101, and hence it should not be granted a patent. The invention just identified post-solution application of a formula, and as a only novel feature of the invention was mathematical algorithm or mathematical formula, it should not be granted patent, is what they said. Then Diamond versus Chakravati case happened in 1980. In 1981, the first patent for software has been gate has been opened with Diamond versus Deere case. In Diamond versus Deere case, the invention related to a dispute over the patentability of the process for molding raw uncured synthetic rubber into cured precision product. The invention involved the process of constantly measuring the temperature inside the mold and feeding the temperature measurements into the computer that repeatedly recalculate the cure time by using of the mathematical equation that is called Arrhenius equation, and then signals a device to open the press at the proper time. So earlier people used to quite frequently open, check, and there used to be burns to the hands when they frequently open and all. But now with this invention, this curing the rubber, only when it cures, it opens the thing. So PTO rejected, saying that it's nothing but mathematical equation along with conventional industrial methods. But Supreme Court disagreed with the patent office and held that invention is patentable. The court held that the process would not be non-patentable subject matter simply because it employs mathematical formula or computer program or digital computer, as long as it produces useful result, useful concrete results. If it produces, that can be patentable, is what the US Supreme Court said. The patent is granted in USA for inventions of some practical method or means of producing a beneficial result or effect, and not for the result itself. Though Arrhenius equation is not patentable, the court opined that the process for curing rubber, which incorporates itself in a more efficient solution of the equation, is patentable. Thereafter, Freeman, Walter, Abel cases, similar things have been processed. The court determined whether mathematical algorithm is recited directly or indirectly in the claimed invention. If yes, the court then checked whether the claimed invention is directed to mathematical algorithm that is applied to or limited by physical elements or process. If algorithm were applied to one or more steps of other patentable process or one or more elements of other patentable product, then the claimed invention would have been granted patented. So all these decisions have been given like that. If the claimed invention were limited to mathematical algorithm, then it would have been not granted patents. Then in 1994, in Re Alpat, invention related to means of creating a smooth wave display in digital oscilloscope. Patent Office rejected the claims. Court disagreed with the Patent Office, held the invention to be machine, which falls under the scope of statutory subject matter. Then the court has come up with a test. Earlier test was not clear. Then so court made an attempt to interpreting Diamond versus Deere case. Useful result. Decision to mean that any computer program which produces concrete, useful, and tangible result is patentable. The court looked at the program computer as a new machine because it believed that the general purpose computer in effect becomes special purpose computer once it is programmed to perform particular function pursuant to the instructions given from the software. The court coined a new test called concrete, useful, and tangible result test. And then inlay lorry, the patentability of memory containing data structure was in question. Patent Office rejected. The appeals board determined that the claims were statutory, but then the printed matter exception, because it is a database data structure, it is denied as a printed matter exception. Then State Bank versus Signature Financial Group, 1998. The invention related to data processing system for implementing an investment structure, which was developed for use in business as an administrator and accounting agent for mutual funds. State Bank tried to obtain a license from license of the software from Signature Financial Group. However, negotiations failed. Then State Bank claimed patent invalidity as it is mere computer program. District Court held patent not valid. However, Federal Circuit Court reversed it. The patent invalidation of District Court. It held that the process patent should not be held invalid merely on the ground that it involves mathematical algorithms, as long as it produces concrete, useful, and tangible result. Thus, it opened doors for the software patents. In Res Komsky, invention relating to mandatory arbitration in legal contracts. So this, there are several other things come up, and courts evolved decisions. And Bilski is one important decision which said that a method of managing consumption risk costs of commodity sold by a commodity provider at a fixed price. The test holded that the process is patentable if it is tied to a particular machine or apparatus, or it transforms a particular article into a different state of thing. So this is called the machine or transformation test. A claim process is patent eligible if it is tied to particular machine or apparatus, or it is transforming particular article into different state of thing. This MOT is not sole test for determining patent eligibility. Instead, it is a useful and important clue and investigating tool is what the court opined. Then abstract idea analysis, the court also suggested that abstract idea analysis has to be done. The concept of hedging is unpatentable abstract idea. Allowing Bilski to patent risk hedging would preempt use of the approach in all the fields and would effectively grant a monopoly over abstract idea. So limiting an abstract idea to a field of use of adding a token post-solution component is not enough, is what the court observed in Bilski. But it again said that it is not the binding opinion. You can go back to section 101. Then after Bilski and Alice cases, after Bilski, although the court explicitly refused to rule on the patentability of software, it appears that software will largely remain patentable. At minimum, the decision would not bar any categorical execution of software patent. The court neither endorsed nor rejected the Federal Circuit Part's interpretation of section 101, noting that nothing in today's opinion should be read as endorsing interpretation of 101. So that is what has been given. Then Alice, the US courts are adopting European model, that is technical effect. If it has a technical two-part test that is tied to a machine or apparatus, or transforming a product, shape of the product. So those are the two-part test. And then whether it is technological or not is what Alice versus CLS holding has been done. So there are several patents that have been granted. Initially in 1985, less than 2,000. In 2000s, more than 18,000 patents have been granted in computer implemented inventions. There are very famous patents that have been like one-click, Amazon.com's one-click patent, which sued Bernard and Noble in 1999 and won in district court and settled undisclosed terms in 2002. Bleesburg Technologies single spread, they have filed a patent and they got initial offering of 14.3 million. Lava Trading Incorporation got 30 million funding because of one single patent. So there are several. Google itself is entire Google empire is built on software patents. Google is now valued about 123 more. I think more than 120. This valuation is pretty old. 123 billions was earlier. Now it can be more. There are several technological areas where software patents can be given: compression technology, natural language translation process, financial software, security software, voting software, communications and interoperability. There are many fields. The case of patents in software industry is no different in theory from the case of patent in other industries. Software patents can help small innovative firms. There are a lot of problems with current patent law, and some of those problems are especially affecting software industry. If you have a recap from 1972, Gottschalk versus Benson, to Bilski and Alice Bank, what happened? Patent can't claim preempt mathematical algorithm, then only claim a particular application of algorithm, and then practical and definite application with useful result, then useful, concrete and tangible result, then reiterated concrete, useful and tangible result, then tied to particular machine or transforming the state. That is what in Bilski has been held. So there are several things that have happened in software is now patentable. Now coming to artificial intelligence, machine learning, and Internet of Things related patents. E-commerce, artificial intelligence in e-commerce can predict behavioral patterns to provide recommendations to users. Healthcare, artificial intelligence is advancing in healthcare industry by providing assistance to doctors. Retail sector, payments at retail stores can be eased out by companies such as Amazon by using artificial intelligence. Manufacturing, robotics, robots can make using artificial intelligence. Self-driving cars, marketing and business. There are several various applications of artificial intelligence. Now, what is an artificial intelligence? What is the interconnection between artificial intelligence and IPR? The ability of machines to perform tasks normally attributed to human beings or animals. That ability to pursue reasoning, planning, acting, and learning is called artificial intelligence. Now, AI is disputing every major industry. We are seeing AI to make its impact on our daily lives, both in visible and invisible ways. And possibilities for this class of technology are almost limitless. It is everywhere. Without AI, now it is very difficult for us to live. Now, what is artificial intelligence? Artificial intelligence is a subject matter of various artificial intelligence is also a subject matter of various patents based on inventions in the field of machine learning, data analytics, natural language processing, and natural language search and machine learning. Artificial intelligence is used to automate existing resources, including human resources and data, to generate return of investments for enterprises. Now, what is the issue between artificial intelligence and patents is patents were designed to motivate an inventor who is a human being. If such motivation still needed for artificial intelligence as an inventor? If machine is inventing something, see, patents are granted to encourage individual to disclose more ideas. If machine is producing ideas, does machine also require patents to motivate them? If artificial intelligence invents something, is it patentable? If it is patentable, who owns the patent? Is it the computer, a machine, or the person who designed that machine? How do we enable a claim if we don't know how artificial intelligence made a decision? So if artificial intelligence has made a machine with its own with its own knowledge and with its own coding, well, how do we make a second machine? If a robot made a machine, how many nuts and bolts it has fixed, that robot alone? No, you don't know. How do you make another machine? If an AI can be inventor, who can be the infringer? If artificial intelligence, a computer is termed as the owner of the patent, who could be the inventor? What remedies are appropriate? If somebody infringes, what should be given? Are there aspects of artificial intelligence that should be accessible to all? What risks exist if someone controls the key artificial intelligence technologies? Is AI patentable, or is it just an algorithm that is a law of nature? Recently, South African Patent Office granted a patent where Dabus, an artificial intelligence as inventor. South Africa, there is no substantive examination. They have granted a patent to a computer called Dabus. In similar lines, Australian court also ruled for a grant of a patent to an AI called Dabus in Australia as inventor. So those are the issues that need to be resolved before artificial intelligence is considered to be patenting and all. Then artificial intelligence and copyright issues will look in. Once we understand copyrights, we'll understand better the patents. Can AI original works be copyrighted? If it is, software written by humans should receive copyright protection. Is AI like animal? The US court have held there is that no one owns a monkey selfie. There is, right, that there is a controversy that monkey has taken a selfie, and who owns that selfie is what a controversy. And the court has deliberated a lot and finally said monkeys, the laws are applicable to human beings, not animals. Animals can't claim rights. Who is the author of inputted data trained model? Is there any sufficient originality, or has originality low bar? Who is the author of output data? All this is a question. Let us see this video. This is automated content creation. Sorry. One second.
GoDaddy offers hosting that's reliable and simple to set up. Get 99
Sir,
points.
your screen is not visible. You need to reshare your screen.
I'll share the screen again. 1 second. Is it visible now?
Yes, sir.
To introduce people
so see this video. This is automated content creation.
Content or titles that might be in book form, game form, video or television form, whereby a computer pretty much does 100% of the work required by a typical human author. The idea is to take a very small amount of information and have a computer basically write the entire book or create the entire movie or create a PC software game, be it for mobile phones or personal computers. Now, I focus mostly on the business of education. This video will step you through a few simple ideas on how one can create title content in a automated fashion. We're going to start with the example of an economist who is given a small piece of information about, let's say, the antipsychotic drug market and wonders what the latent demand would be for that same product worldwide across all market areas. Using a little bit of artificial intelligence, a computer program has been created that mimics the thought process of someone who would be responsible for doing such a study. But rather than taking many months to do the study, the computer accomplishes this in about 13 minutes. The way it works is you see something in the newspaper that tells you some small piece of information like the market is about $11.5 billion. How large is the market in other countries of the world? If we can open up the application and start the process, you'll discover that it doesn't take that much data input for the computer to discover what's the optimal econometric model to apply to such a scenario. And so what the computer does is basically open up a main form. We then give it instructions on basic things like, I want to do a study on topic X. You select the priors or what you already know about that subject, and it may be very little information. Then you launch the application by giving it simple instructions like write a report over year X to year Y, and then it'll immediately start thinking, well, given the small amount of information, what is the optimal model that could be applied to this question? How would I organize the data? What would be the implications across countries, given income distributions and given the amount of information that I've been given? Then it simply opens a Word document and starts creating the report based on the econometric models that it's been nested with. It then reasons through all of the different countries one by one, outputting one page after another, and it will do so in a fairly quick order. The screens you see here is a relatively slow computer, and typically it in fact doesn't even show up on a screen. These are being run on servers that do it automatically. It will then open a Word document and export the information into Word, just like a real author would out of their minds, so to speak, or out of spreadsheets. And then it formats that information, and it uses a number of editorial rules, in essence, the intelligence of what an editor uses to format a document. Once in a while, it'll discover something interesting, like a variance in the data, and it'll simply create a graph, knowing that that might be interesting to the reader. But it formats it in such a way that it actually doesn't violate editorial conventions. It continues about its way, formatting, putting headers and footers, and making summary statements based on the information that it's been able to create from the econometric models that were back in the database program using queries. Once it's done all of that repetitive cleanup, it will then save the document, update its table of contents, and then produce a 235-page report. This is only an example of this.
So this automated content creation software writes a book like if you are a PhD scholar and you research and write a book, you take 1 year or 2 year or 3 years time. But this software does all that research like you, scrolls the internet and gets the data and writes the book within 13 minutes. A 283 pages book, it has written in 13 minutes.
Right now,
And it also does several other things, like it creates videos on its own. So this by this software itself, you can do several things.
Table of contents, chapters, chapter headings, summaries of the results, summary of conclusions, and many other issues that might be related to the methodology of preparing the report, given the information that was available for this report. Most reports are actually run automatically without human inputs, but this gives an illustration of how it actually works. I haven't just done books that were econometric in nature, but also education books like crossword puzzle books. If you go to Google Books, you can simply search for things like Chinese crosswords, and you'll discover that crossword puzzles can be created completely by computer. But it's not just a puzzle, but an entire book where there's a logic across the different puzzles so that words are not repeated too often. The easiest words appear first. Now, this is a Chinese crossword puzzle books where the clue is in Chinese and the answer is in English. And this is for people who want to learn English if they're Chinese speakers. Later in the book, when the puzzles are more difficult, you'll notice that the title of the puzzle changes as well as the word. One book covers about 3,000 words. Other titles include annotated classics works. So if a Spanish speaker wants to read an English classic, in the footnotes, you'll see the translation of the most difficult words. Again, the computer determines what those are and makes sure that no word is repeated page after page. Also posted many other genres. Those can be found at Amazon.com. Those other genres include healthcare guides, whether they're targeted towards or useful for patients or for physicians. Both genres were created. And probably you would not see these books produced using human methodologies because some diseases are so rare, there might only be 10 people in the world that have that disease. So no publisher would normally publish such a book, but using computers to do this instead, to create this content, allows for these very thinly sold titles actually to be published. And many patients find these quite useful as well as physicians. The methodology is independent. And one database video project I'm working on, word of the day, in about 600 different languages. This one is related to my online dictionary.
And now, Webster, the tomato, explains to Dr. House his Rolling Stones symptom of the day.
My tongue is swollen. Macroglossia.
So that was basically a software that has been made a software that basically what you call automated content creation software that has been filed patent way back in 2000, and a patent was granted in 2007. And that's what the content is being generated using artificial intelligence by computer. It is an automated content creation. Now, who is the author of that book? Is the book is authored by the person who created this software or the computer itself? These are the issues. So before dealing with this issue, let's talk about this monkey selfie case. Monkey selfie case, whether it is copyrightable by monkey or human is the question. Narrato versus David Slater case number is so and so. The court held that monkey is not an author within the meaning of US Copyright Act. Further, the court also said that even if Narrato had taken a picture by independent autonomous action, the suit would not constitute, as animal does not have any standing before the court of law. So even if it is its own creative work, if we are seeing some elephants painting and all, right? If that painting is created by elephant also, if you copy it, elephant can't go and file a case, is what the court opined. After the case was dismissed by the California court, PETA filed an appeal before the US Ninth Circuit, and the appeal also, the US Court of Appeal for Ninth Circuit, while referring to the issue number 1 and Kazakhstan community case, said that in the present case, the complainant PETA alleges that Narrato is the author and owner of this monkey selfie. The complainant further alleges that Narrato has suffocated concrete and particularized economic harms as a result of infringing conduct by the appellees, David Slater. Harm that can be redressed by judgment declaring Narrato as author and owner of the monkey selfie. Further referring to Kazakhstan community case, the court said that Kazakhstan crafted a simple rule of statutory interpretation. If an act of Congress plainly states that animals have statutory standing, then animals have statutory standing. If the statute does not so plainly state, then animals do not have statutory standing. The Copyright Act does not expressly authorize animals to file copyright infringement suit under the statute. Therefore, based on the court's precedent in Kazakhstan, Narrato lacks statutory standing to sue under the Copyright Act. The US Court of Appeals for Ninth Circuit, while answering the second issue, said that we gravely doubt that PETA can be validly assert next friend. So if not the animal per se, the next friend can file it. So the court said that it can't validly assert as next friend status to represent claims made by the monkey, both because number 1, PETA has failed to allege any facts to establish requires significant relationship between next friend and real party in interest, and B, because an animal cannot be represented under our laws by a next friend. So therefore, based on the above 2 points, the court affirmed the decision of Californian court and dismissed the suit brought by PETA, which means such photographs or selfie will neither be protected by under copyright of the animal or nor a human, and therefore will fall under public domain. Also, the US Court of Appeal for the Ninth Circuit ordered PETA to pay attorney fee to David Slater, including incurred during the appeal. So the photograph what has been taken by monkey is neither protected to the animal monkey nor to a human being. It is falling in public domain is what the court opined. And recently, very recently, very interesting thing happened in India. Indian Copyright Registry has granted a copyright registration for Raghav. Raghav is a computer app as an author. A copyright has been granted to Raghav as an author, but copyright is not granted to Raghav. Raghav is been narrated as an author. So Copyright Registry, Indian Copyright Registry recognized AI, computer, as an author, but ownership is given to the person who developed that author. The producer is the owner of the copyright, but author of the copyright is AI has been recognized. Initially, the registry, when replied Raghav as a sole author and owner of the copyright, it refused. However, on application by individual, along with AI app has registered the copyright. So a co-author has been initially sole author has been made Raghav as a sole author. Then the copyright application has been refused. But along with Raghav, a software developer has been made as a co-author. Then application is granted registration. So that is how the artificial intelligence has been dealt in US and India. So artificial intelligence, unless it has a human being along with them, the artificial intelligence per se will not be protected. There should be patents will not be granted to machines. Patents will be granted to individuals. That is what the those case laws say. So in Europe also, copyright for softwares, Copyright Directive 91 bar 250 EEC requires copyright law recognize software as a literary work. And however, section Article 52 of Patent Convention, patent shall be granted for new inventions which are susceptible of industrial application, which are new and which involve into step. However, there are certain exclusions. Exclusion include computer programs as such. So because computer programs as such, computer programs for computer, however, these things are stated to be excluded only to the extent they relate to that thing as such. That means if it is mixed with something else, it can be patentable, is what Europe also said. So I'll skip this slide. The European Patent Office very particularly states that patent will be given to software also. However, it should have technical character. What is technical, what is technological is not been defined anywhere. Inventions having technical character as far as EPO is concerned, which are or may be implemented by computer programs, may be patentable. However, the word technical has not been defined. So what is technical to me might not be technical to you all. So what is technical to you all might not be technical to me. So it depends upon the perception of the person who is viewing the product. Technical makes a technical contribution in field not excluded from patentability, is a solution to a problem involving technical consideration, produces a technical effect going beyond the normal interaction of the computer program, or just generally has a technical character. All these have been patented. There is what is called little man test. The question to ask should be, is it new and non-obvious merely because there is a computer program, or would it still be new and non-obvious in principle even if it is same decisions and commands could somehow be taken and issued by little man at the control panel operating under the same rules? For if the answer to the later question is yes, it becomes apparent that the computer program is merely a tool and the invention is not about computer programming at all. Then Viacom case, there are several other cases where Europe has decided patents need to be granted. I will not talk about much. Now coming to Indian patent law on software patents, Indian patent law, Indian Patent Act 1970, algorithms and softwares was excluded. 1999 amendment, with 1999 amendment, the earlier software, entire software is excluded, but 1999 amendment added a word called per se, software per se. Like in Europe as such, in India they have used the word per se. Software as a per se will be not patented. However, software embedded is patented, is what that means. From 1999 to 2005, that was the thing. In 2005, amendment in ordinance form stated a computer program per se, other than the technical application to industry or a combination with hardware or mathematical method or a business method or algorithm is patentable, is what 2005 amendment said. Then the Indian Patent Act tried to strike balance between rights of the patent holder and his obligation to the society that grants him such rights. There is section 83 which says that it has to be industrially made and all. The Act specifically excludes computer program per se. The Act also excludes mathematical algorithm and business method. Then there are a draft manual of patent examination which directed the examiners not to grant patents to computer programs. Then guidelines on examination of computer-related inventions have been issued in 2013. Then that was been updated by 2016, provided illustrative examples of non-patentable computer-implemented inventions. Then they have issued revised guidelines for examination of computer-related inventions in 2007. Under the provisions of those provisions, Indian Patent Draft Manual said under the provisions, mathematical methods, business method, computer programs per se, and algorithms are not considered to be patentable inventions in relation to computer programs. The law provides a qualification that what is not patentable is only computer program per se. Claims directed at computer program products or computer program per se stored in computer readable mediums are such are not allowable. Otherwise, embedded software is allowable, is what draft manual said. Then in 2013 guidelines, they tweaked and they tried to get some more programs which are technical in nature can be patentable. Examiners may rely on the following three-stage test in examining computer-related inventions. properly construe the claim and identify the actual contribution. If the contribution lies only in mathematical method, business method, or algorithm, deny the claim. If the contribution lies in the field of computer program, check whether it is claimed in conjunction with novel hardware and proceed to other steps to determine patentability with respect to invention. The computer program in itself is never patentable. If its contribution lies solely in the computer program, then deny the claim. If the contribution lies in both computer program as well as hardware, proceed to other steps of patentability is what the guideline said. Then there are several decisions came from the patent office. There are several granted cases. There are several rejected cases. While drafting a software patent application, one should keep in mind patentability criteria under Section 3K of the Patent Act, which bars the mathematical or business method or computer program per se or algorithms. But if it is embedded system, definitely it is patentable. However, the decision of IPAB, Intellectual Property Appellate Board, in the case of Fred Alney, states that the computer invention that meets the criteria of a technical effect are patentable under the law. Artificial intelligence and related technologies are all pervasive and permeating into every sector of business. As far as protection of artificial intelligence is concerned, the Indian Patent Act currently provides protection only to the true and first inventor, which implies a legal person, which includes either a natural person or an artificial person, that is a corporation. So it should be a person to grant a patent is what the Patent Act, Indian Patent Act says. Section 3K of the Patent Act 1970 clearly states that mathematical or business method or computer program per se or algorithms are excluded from patentability. In case of Farid Alney, IPB states that the computer invention that meets the criteria of technical effect are patentable under law. This order opened the doors of the enormous corpus of innovation to now become protectable and are more valuable, as patent protection for innovations in India is essential for fostering innovation. The similar decision has been given by Delhi High Court on computer-related invention. Delhi High Court has reiterated the computer-related inventions demonstrating technical effect or technical contribution are patentable, even though it may be based on computer program. The judgment issued in the case of Farid Alney versus Union of India and others. In the end, the court held that across the world, patent offices have tested patent applications in this field of innovation, that is software, on the fulcrum of technical effect and technical contribution. So across the world, everywhere, whether you take Europe, whether you take US, everywhere, the test is whether it is technical effect or technical contribution. If the invention demonstrates a technical effect or technical contribution, it is patentable, even though it may be based on computer program. The court further held that the patent application deserved to be considered in context of settled judicial precedents, which now have laid down interpretation of Section 3K. The guidelines and other material include the legislative material. Accordingly, the court directed the patent office to re-examine the application, giving the applicant an opportunity of being heard and issue a decision within 2 months' time. So that is what has been done. Australia also, on software related patents, they also say that digital business and software patents are ever increasing, and they also open the doors for software patents. One of the application, Intel application, a device having a credential management system and a method of operating same that has been filed, has been rejected in India. However, the same has been granted in USA. So such is how the patent system is. So there are some proposals for sui generis protection for software also. Why not, like plant variety registrations? Software should also have a separate registration system, not under copyright, not under patents, but copyright registrations and the software registration separately is what been in demand. Software seem to have problem with both copyright and patents. That's the reason new right that has a shorter lifetime. We don't require 20 years, 30 years. We require not like under copyright lifetime of other plus 60 years. Maybe short period of time, very good software, artificial intelligence software, short period of time, 5 years, 10 years, you can recognize and protect both literal and functional aspect of software is what people are demanding. So if there are any question and answers, I'll take up.
Right. Thank you very much sir, for providing a brief idea about how AI and related applications can be patented and what are the options available with us. So, sir, there is a question regarding. So, can you help me in understanding the Section 3K of Indian Patent Act?
Okay.
Vis-a-vis
Section
2019 bag of US PTO in context of CRI?
Yeah, Section 3K actually initially Section 3K excluded complete mathematical application or algorithm or computer program if it is there, completely excluded earlier. But it has been amended, and Section 3K now says that computer program per se, if you file computer program as it is, which is working on a general purpose computer, that will not be patented. But if it is a machine, if it is tied to a machine, or it transforms a particular thing to a different state of being, then it can be patented. If it has a technical effect, what is Fred, the IPAB and Delhi High Court has given judgment is, they are saying that if your software is contributing to some technical advancement, some technical contribution, then it can be patented. However, the word technical has not been defined anywhere. Nobody can be defining, nobody can dare to define the word technical, because what is technical, defining it is very difficult to anyone. So that's the reason we need to when we file applications of software or AI related or IoT related patent applications, we need to say that there is a technical contribution. And what is the technical contribution, you need to demonstrate to the court to understand that that involved some technology. When court understands there is some technological involvement, definitely patents will be granted to it.
So, 3K versus 2019 PEG of US PTO in context of CRI.
I didn't get what is PEG.
Rohit Mishra, can you please clarify what exactly?
Your question is, yeah.
Yeah. So meanwhile, I will take another one.
Sure.
That if we create a software which will support some of the medical hardware equipment, for example, MRI machine. MRI machine have pre-built image processing software or third-party software. If we create for existing MRI machine, so can that particular software be patentable?
Certainly. That is what the patent office, even earlier, not now, even earlier also it is patentable, because it will be considered as there are two softwares. A software which runs on general purpose computers, that is regularly what we are using, laptops and desktops, and software which will work on specific purpose computers like MRI scanners or Xerox machines or TV remotes. These are different equipments. So if you write a software to handle those kind of hardware elements, then it can be definitely patentable. Even not now, it is much before,
Right.
because the per se, in 1999 itself, the computer program per se is not patentable, is what has been introduced. So from
Right.
that point onwards, it is patentable.
Right. So, Sir Rohit Mishra was asking about patentability eligibility guidelines. So, 3K versus 2019 patentability eligible guidelines.
Bank, the Section 3K is aligned with the guidelines issued by USPTO, US courts, which says that machine or transformation test, whether the software is attached to machine or whether software is transforming a particular thing to different state of being. So
Right.
machine or transformation test has been included into Section 3K by 1999 amendment.
Right. So, thank you very much, sir, once again for providing your valuable time for us. So,
Thank you.
tomorrow also we have scheduled a session of Vijay sir, and
Correct.
definitely we will try to And Vijay sir will discuss patent search strategies for computer-related inventions, and also will provide shortcuts and tips for effective searching. So once again, thank you, sir. We will meet once again tomorrow. Thank you very much,
Thank
sir. And dear participants, our next session will start at 3:15 sharp. So the link for the same is already shared with you. So I request everyone to join that session. Thanks a lot.
Thank you.